Most relationships end with a conversation, a lawyer, a moving truck. It hurts, it costs money, and eventually you move on. For the victims in these cases, that was not an option. The person they had chosen, the one they had built a life with, had already decided that death was simpler than divorce, that a bullet was cleaner than a custody hearing, that a fire, a hammer, a hired stranger, or an open phone line was the logical end to a marriage that had stopped working. These were not crimes committed by dangerous strangers. They were committed by police officers, school administrators, insurance agents, and tax accountants. People with church attendance records and neighbours who described them as perfectly normal. People whose victims never saw it coming because nothing had prepared them for it. Today we are covering 10 relationships that ended with one of them on death row. Case 1. Chad Daybell and Tammy Daybell, Idaho. Sentenced to death, June 1st, 2024. Currently on death row. Chad Daybell and Tammy Daybell were married on March 9th, 1990 in Manti, Utah. They were 21 and 22 years old. Over the next 2 decades, they built what looked like a quiet, ordinary life in Springville, Utah. They had 5 children together: Garth, Emma, Seth, Leah, and Mark. Chad worked as a gravedigger and ran a small publishing company called Spring Creek Book Company with Tammy, where he wrote and sold religious books about the end of the world, second chances at life, and spiritual visions. In their community, they were seen as a devout, stable couple with deep roots in their faith. Their children were grown or nearly grown. They had been together for almost 3 decades. Everything that happened next is why Chad Daybell now sits on death row in Idaho. To understand how a 29-year marriage ends with 3 bodies on a rural property, you have to start with who Chad Daybell was becoming before the worst of it started. His books were not standard religious reading. They dealt with end times prophecy, spirits crossing between life and death, and a belief that certain people were chosen for a special role in the final days before the world ended. He gave talks at religious conferences. He had a following. At one of those conferences in October 2018, he met a woman named Lori Vallow. Lori was 45 years old, charismatic, and on her 4th marriage. She and her husband Charles Vallow were already in trouble. Within weeks of meeting Chad, Lori and Chad were exchanging emails and texts about their beliefs, their shared sense of spiritual destiny, and each other. The messages became romantic within months. By early 2019, they were having an affair. Tammy had no idea. Their children had no idea. Lori's husband had no idea, though he would eventually find out and file for divorce in February 2019. What nobody knew yet was how far Chad was willing to go to remove every obstacle standing between him and Lori. The situation escalated faster than anyone could have tracked in real time. In July 2019, Lori's brother Alex Cox shot and killed Lori's estranged husband Charles Vallow at their Arizona home. Authorities initially ruled it self-defense. Alex Cox died of natural causes in December 2019, before anyone could charge him with anything. In September 2019, Lori moved to Rexburg, Idaho, the same town where Chad lived with Tammy, bringing her 2 youngest children with her, 16-year-old Tylee Ryan and 7-year-old JJ Vallow, who had autism. The same month they arrived in Rexburg, both children were last seen alive. Chad was still living with Tammy. The texts between Chad and Lori during this period showed a system they had built together, a numerical rating scale to classify people around them as light or dark, as spiritually clean or possessed. Family members, including Tammy and the children, had been assigned ratings. Being labelled a zombie, in their private language, meant a person's spirit had been taken over by a dark force. It also, as prosecutors would later argue, served as a religious justification for what came next. On October 19, 2019, Tammy Daybell was found dead inside the home she shared with Chad. She was 49 years old. Chad told authorities she had died in her sleep. He said she had been ill. He told investigators he did not want an autopsy. The coroner accepted his account and ruled her death natural causes. Chad's neighbours and Tammy's own family said she had seemed completely healthy in the days before she died. Her sister testified she had visited Tammy on October 14th and that she was energetic and fine. 16 days after Tammy's death, Chad Daybell flew to Hawaii and married Lori Vallow. Prosecutors later revealed that Chad had taken out 2 life insurance policies on Tammy, totaling $430,000, with himself as the beneficiary, and that he had done so the month before she died. Within 24 hours of reporting Tammy's death, Chad sent Lori a text message saying, "I know exactly how you feel. I am feeling sad, but it is not for the reason everyone thinks." JJ and Tylee were still missing, though the world did not yet know that. By December 2019, law enforcement in Idaho had begun looking for JJ and Tylee. Their grandparents, Kay and Larry Woodcock, had not been able to reach JJ since August. When police checked on the children, Lori told them the kids were fine and with family. It was a lie. In February 2020, police arrested Lori in Hawaii on felony charges related to the disappearance of the children. She and Chad maintained the children were safe. In June 2020, investigators obtained a warrant to search Chad's property in Fremont County, Idaho. On June 9, 2020, they found both children buried on the grounds. Tylee's remains had been dismembered and burned. JJ's small body had been wrapped in plastic bags. Both had been killed in September 2019, the same month Lori moved to Idaho. Tammy's body was exhumed. Forensic examination determined she had been smothered. The death that had been ruled natural was a murder. Chad was arrested the same day the children's bodies were found. The trial of Chad Daybell opened on April 10, 2024, at the Ada County Courthouse in Boise, Idaho. Prosecutors called 67 witnesses over the course of the proceedings. The case they laid out was methodical. Phone records showed near constant communication between Chad and Lori around the time each person died. Text messages introduced at trial showed Lori telling Chad she needed things to change, that she could not be with him until they did. Prosecutors argued that Tammy was the obstacle and that Chad removed her. The insurance fraud charges were directly tied to the $430,000 in policies Chad had taken out on Tammy in the weeks before her death. Witnesses described the zombie classification system Chad and Lori used to label people in their lives. Former colleagues of Tammy testified she had been healthy and engaged at work until the day before she died. Chad's defense team, led by attorney John Pryor, argued that Lori had drawn Chad into her world, that she had manipulated him, and that she was the true architect of the murders. Chad did not testify. The jury began deliberating on May 29, 2024. On May 30, 2024, the jury found Chad Daybell guilty on all counts. 3 counts of first-degree murder for the deaths of Tammy, JJ and Tylee, conspiracy to commit murder, and 2 counts of insurance fraud. 2 days later, on June 1, 2024, the jury unanimously recommended the death penalty. Judge Stephen Boyce accepted the recommendation and sentenced Chad to death. Chad said nothing to the court. He showed no visible reaction when the sentence was read. Victim impact statements were given the day before sentencing. Kay Woodcock, JJ's grandmother, stood before the court and described the weight of his birthday passing every year without him. He would have celebrated his 12th birthday just a few short days ago, she said. It is now grief we are confronted with yearly. Tammy's father, Ron Douglas, told the jury, "It makes me angry, and it destroys me to know Tammy was treated how she was." Colby Ryan, the only surviving child of Lori Vallow and the older brother of JJ and Tylee, addressed the court last. "I have lost everything I have ever known," he said. Chad Daybell is now held at the Idaho Maximum Security Institution in Kuna, Idaho. He is one of fewer than 10 people on Idaho's death row. His attorneys filed a notice of appeal to the Idaho Supreme Court on June 5, 2024. Lori Vallow Daybell was convicted separately in May 2023 and sentenced to 3 consecutive life terms without the possibility of parole. She was later extradited to Arizona, where she was convicted in April 2025 of conspiring in the murder of Charles Vallow. Idaho has not carried out an execution since 2012. Chad Daybell was 55 years old when he was sentenced to die. Tammy was 49 when she was smothered to death in her own bed. JJ Vallow was 7. Tylee Ryan was 16. A man who spent decades writing books about the afterlife ended 3 lives to get to a woman he had known for less than a year. There are no parole hearings in his future. There is no release date. The next case involves a woman who did not pull the trigger herself, but every piece of evidence showed she had been planning the murder for months, and the man she wanted dead was her own husband. Case 2. Mark Sievers and Dr. Teresa Sievers. Florida. Sentenced to death, January 3, 2020. Currently on death row. Mark and Teresa Sievers met through Mark's sister, who was a close friend of Teresa's. They married in 2003. By 2006, the couple had relocated to Bonita Springs, Florida, and opened a medical practice together called Restorative Health and Healing Center in nearby Estero. Teresa was the doctor. She had spent years working toward that, building a reputation in holistic and integrative medicine. The practice grew. Patients respected her. Local publications wrote about her. Shortly before her death, a women's magazine in the area ran a profile on her. She and Mark had 2 daughters together, aged 11 and 8 at the time of her murder. On the surface, the Sievers family looked like a success story. A physician mother, a supportive husband, 2 kids, a thriving practice, a house in southwest Florida. What Teresa apparently did not fully know was that her husband had already decided she needed to die. The marriage had problems that Mark kept mostly to himself. He would later tell investigators and associates that he was unhappy, that he felt controlled, that he feared Teresa would take the children from him if they separated. Prosecutors argued the real issue was money. Teresa's medical practice generated substantial income, and Mark had taken out 5 life insurance policies on her life, totaling $4,433,000. He was the sole beneficiary on all of them. He had also confided to at least one person close to him that he was thinking about ways to solve his marriage problems permanently. In May 2015, Mark travelled to Missouri for the wedding of his childhood friend, Curtis Wayne Wright Jr. The two had known each other for years. During conversations over the wedding weekend, Mark brought up his marriage. He told Wright that Teresa was going to take the children and that he couldn't afford a custody fight. Wright told him there was only one real solution. According to Wright's later testimony, Mark agreed. Over the course of several conversations, the 2 men planned how Teresa would die. Mark told Wright the murder had to look like a burglary. He gave Wright detailed instructions about the house, the layout, the security system, when Teresa would be alone. Wright agreed to carry it out in exchange for a share of the insurance proceeds. Mark flew home to Florida. Teresa had no idea any of this had taken place. Wright then recruited a 3rd man. Jimmy Ray Rogers was a career criminal from Missouri who had no prior connection to the Sievers family whatsoever. Wright promised Rogers a cut of the insurance payout. On June 27, 2015, Wright rented a car in Hillsborough, Missouri, and picked up Rogers. The 2 men packed coveralls and gloves. They drove more than 1,000 miles south to Bonita Springs, Florida. A GPS device in the rental car tracked the entire route. Surveillance footage from a gas station along the way captured both men. They arrived at the Sievers' home in the early hours of June 28th. Teresa was not there yet. She had been on a family vacation in Connecticut with Mark and their daughters. Mark had arranged for Teresa to fly home alone a day early, while he remained in Connecticut with the girls. That separation was deliberate. It gave Mark an unshakable alibi and delivered Teresa into an empty house. Wright and Rogers arrived, disabled the security alarm using the code Mark had provided, and entered the property. They left briefly, drove around, and returned later that evening. They put on their coveralls and gloves and pried open a side door that was already unlocked. The prying was staged to simulate a forced entry. Then they waited inside the dark house. Sometime after 10 p.m, Teresa Sievers came home. She pulled into the garage, she gathered her things, she walked into the kitchen. Wright and Rogers were waiting. They beat her with hammers. She was struck 17 times. The medical examiner would later confirm that most of the blows were delivered while she was already on the ground, still alive. She died in her own kitchen, while her husband sat in Connecticut with their children. Teresa's colleague, Dr. Daniel Patritz, found her body the following morning. Mark had called him and given him the garage code, suggesting he just walk in rather than knock. That detail struck investigators as strange from the start. Why would a husband, concerned about a wife who hadn't checked in, give a colleague the garage code and tell him to walk directly in rather than knock at the front door? When Dr. Patritz entered the kitchen and found Teresa face down in a pool of blood, police were called. The crime scene showed a hammer. It showed blood. It showed signs of staging that didn't hold up to scrutiny. Mark returned to Florida and appeared grief-stricken at Teresa's funeral. He reportedly had a gun strapped to his waist at the service. Weeks passed, no immediate arrests. The case seemed stalled. The break came through a phone call made to law enforcement in Illinois 2 weeks after the murder. Someone had come forward with information. The lead eventually pointed investigators toward Wright. Police in Missouri obtained a warrant and searched his home, seizing his cell phone and the GPS unit from the rental car. The data was damning. Text messages placed Wright and Rogers on a route consistent with driving from Missouri to Bonita Springs and back. The GPS confirmed it. When detectives interviewed Rogers, his girlfriend told police separately that Rogers had admitted to her he had killed someone in Florida and that a man named Sievers had paid for it. That statement cracked the case open. Wright was arrested. Rogers was arrested. In December 2015, court documents identified Mark Sievers as the man who had orchestrated everything. He was arrested on December 26, 2015, 6 months after his wife's murder, and charged with first-degree murder and conspiracy to commit murder. Wright accepted a plea deal. In exchange for his testimony against Mark and Rogers, he pleaded guilty to second-degree murder and received a 25-year prison sentence. Wright took the stand at Mark's trial and described in detail the conversations at the wedding, the planning, the drive to Florida, what happened inside that kitchen. He described Mark telling him the murder needed to look like a robbery gone wrong. Rogers went to trial first. In October 2019, a Lee County jury found him guilty of second-degree murder, and he was sentenced to life in prison. Rogers was not convicted of the higher charge because the evidence directly tying him to the planning was weaker. He was the hired hand, not the mastermind. Mark's trial began in November 2019. Prosecutors walked the jury through the GPS records, the phone data, the timeline, the insurance policies, the conversations Wright recounted from the wedding weekend. They presented the 5 life insurance policies on Teresa, totaling more than $4 million, and pointed out that Mark was the beneficiary on every single one. They argued that the man in Connecticut with his daughters, while his wife was being murdered, had engineered every piece of it. Mark's defense team argued that Wright had fabricated the story, that Wright was a man with his own legal troubles who had every incentive to shift blame onto someone else, and that Mark had no real motive to kill a woman whose medical practice was the financial engine of the family. Mark did not testify in his own defense. On December 4, 2019, the jury deliberated for 4 hours and returned a guilty verdict on both counts. The jury unanimously recommended the death penalty during the sentencing phase. On January 3, 2020, Judge Bruce Kyle sentenced Mark Sievers to death. Mark stood before the court and addressed the judge directly. He said his daughters had already lost their mother, and now they were about to lose their father too. He asked the judge for a life sentence rather than death, not to spare himself, but to spare his children. Judge Kyle denied the request and accepted the jury's recommendation. Mark was sentenced to death for the first-degree murder of Teresa Sievers, and an additional 30 years for conspiracy, to be served at the same time. Teresa's mother, Mary Ann Groves, read a victim impact statement to the court. She described what it meant to lose not just a daughter, but to watch her granddaughters lose their mother. She told the court that a piece of her died the day Teresa did and had never come back. Mark appealed. In November 2022, the Supreme Court of Florida reviewed the case and issued a 38-page ruling affirming both the conviction and the death sentence. The court examined claims about the jury process, the use of aggravating factors, and the admission of evidence. All were rejected. The conviction stood. Mark filed for post-conviction relief, arguing his trial attorneys had been ineffective. That hearing took place in October 2025 in Lee County. Among those who testified was Jimmy Ray Rogers himself, who appeared in court and stated that Mark had no involvement in the murder and that Wright had acted alone. Rogers' credibility was undermined by his prior inconsistent statements and the physical evidence connecting the planning directly to Mark. The post-conviction process remains ongoing. Mark Sievers is currently held at Union Correctional Institution in Rayford, Florida. He has been on death row since 2020. He is in his late 50s. Teresa was 46 years old when she was murdered. Their daughters, who were 11 and 8 when they lost their mother, were later placed in the custody of Teresa's family. Teresa's mother was awarded custody. In 2020, a wrongful death lawsuit was also filed and resolved. The two girls grew up without either parent, their mother murdered in the kitchen of their home, their father convicted of orchestrating it. Curtis Wayne Wright Jr. is serving his 25-year sentence. Jimmy Ray Rogers is serving life. The man who drove the plan, who sat in Connecticut waiting while two men with hammers walked into his house, who collected sympathy at a funeral he had arranged, is waiting on death row for a date that has not yet been set. Florida carries out executions. It has an active execution chamber. Mark Sievers knows that. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case involves a woman who watched her husband get shot in their own garage and told police she had no idea why it happened. But 147 letters recovered from the scene told a completely different story. Case 3. Brenda Andrew and Rob Andrew. Oklahoma. Sentenced to death. 2004. Currently on death row. Rob and Brenda Andrew had been married since 1984. Rob was 42 years old when he was killed, healthy, and by all accounts doing well. He worked as an advertising executive in Oklahoma City. They had 2 children together and had lived what looked like a normal, suburban, middle-class life. But by the late 1990s, the marriage was falling apart. The couple separated, and Rob eventually filed for divorce. The proceedings were contentious. There were disputes over finances, over the children, over property, and somewhere in the middle of those disputes sat an $800,000 life insurance policy that would become the most important document in what followed. In February 2000, Rob purchased that life insurance policy. The agent who sold it to him was a man named James Pavat. The policy listed Brenda as the sole beneficiary. It was a standard transaction between an insurance agent and a client. What was not standard was that Pavat and Brenda Andrew began a sexual relationship not long after that policy was sold. By the time Rob had moved out of the family home and the divorce proceedings were underway, Brenda and Pavat were involved with each other and had been for some time. Pavat told his own girlfriend, Christy Larson, that Brenda had asked him to kill Rob. Larson did not go to police. She kept the information to herself, but she was listening. The divorce became bitter in a very specific way. The $800,000 life insurance policy was now a problem. Rob, who was 38 years old and in good health, was fighting to have the policy transferred or contested as part of the divorce settlement. He did not want Brenda to remain the beneficiary on a policy that large. Brenda and Pavat allegedly tried to prevent the transfer by forging Rob's signature on ownership documents to keep the policy in her name. The forgery was discovered and became part of the ongoing legal dispute. Pavat also made a move that prosecutors later described as significant in its timing. Hours before Rob was shot, Pavat moved his washer and dryer into Brenda's home. He was settling in. He had plans. On the evening of November 20th, 2001, Rob Andrew came to the family home. Brenda and Rob were still navigating the legal proceedings. Rob walked toward the garage. At some point that evening, someone shot him twice with a 16-gauge shotgun. As he lay on the floor, someone shot him 2 more times with a .22 caliber handgun. He died on the floor of his own garage. Brenda Andrew was also shot, a wound to her arm. She told police 2 armed men had broken in and carried out the attack. She said she had no idea who they were or why they had come. The physical evidence did not support her account from the start. Forensic examination of the gunshot wound to Brenda's arm showed powder burns on her clothing and skin, consistent with the shot being fired from within 2 inches of her arm. If an unknown attacker had shot her from a normal distance during a home invasion, those burns would not be present. Investigators noted this immediately. Brenda did not attend Rob's funeral. Instead, She left Oklahoma City with James Pavat and her 2 children. They drove to Mexico. While Brenda and Pavat were in Mexico, investigators were working backward through the evidence at the scene and through the people around them. Christy Larson, Pavat's girlfriend, came forward. She told investigators what Pavat had told her, that Brenda had asked him to kill Rob. She also gave them something physical, a .22 caliber shell casing she had found on the floorboard of her car after Pavat borrowed it and returned it on the day of the murder. He had told her he was going to get the car serviced. It had not been serviced. There was a shell casing on the floor. Larson had also secretly written down the serial number of a gun she had seen, which matched the caliber used in the murder. When investigators searched the property of Brenda's neighbours, a couple who had been out of town on November 20th, they found a 16-gauge shotgun shell and several .22 caliber bullets hidden inside. There was no sign of a break-in at that property. Brenda had a key. 8 days before the murder, a witness told police they had seen Brenda at a rural area outside Oklahoma City, commonly used for target practice. That same witness said they later found 16-gauge shotgun shells at the location. Rob owned a 16-gauge shotgun. When he had moved out of the family home, Brenda had refused to let him take the shotgun with him. Investigators also looked at Rob's life insurance policy closely. As his divorce lawyers were fighting to remove Brenda as the beneficiary, the policy had become a flashpoint. Brenda and Pavat had allegedly forged Rob's signature on a form to prevent the transfer. The policy, and the $800,000 it would pay out on Rob's death, was going to disappear from Brenda's future unless something else happened first. Brenda and Pavat ran out of money in Mexico. They crossed back into the United States and were arrested at the border. Pavat, when questioned, confessed to the shooting. He said he had done it with a friend and denied that Brenda had any knowledge of the plan. His denial did not hold. The evidence against Brenda was substantial enough that prosecutors charged both of them with capital murder. Pavat was tried first. An Oklahoma jury convicted him in 2003 and sentenced him to death. Then it was Brenda's turn. Brenda Andrews' trial in 2004 became one of the most debated capital cases in Oklahoma history, though not for the reasons most murder trials attract attention. Prosecutors built a case around the insurance motive, the physical evidence, the flight to Mexico, the forged documents, and Pavat's testimony. But they also filled the courtroom with witnesses who testified about Brenda's personal life in ways that had nothing to do with whether she had conspired to kill her husband. Witnesses described her clothing at restaurants. Multiple witnesses took the stand specifically to comment on outfits she had worn, calling them provocative. Testimony covered her sexual partners going back 20 years. One prosecutor, in closing argument, opened a suitcase belonging to Brenda and held up her underwear in front of the jury, asking aloud whether a grieving widow would have packed those items. A book found in her home called 203 Ways to Drive a Man Wild in Bed was introduced as evidence. A witness referred to her using a crude sexual slur, and while the state later disputed whether the comment was directed at her personally, the jury heard it. Brenda's attorneys argued that the state had a circumstantial case and had chosen to fill the gaps not with evidence, but with character attacks, designed to make the jury dislike her. They pointed out that Pavat himself had denied she was involved, that the physical evidence showed Pavat committed the shooting, and that convicting her required accepting the testimony of a man who had every reason to cooperate with prosecutors to potentially improve his own situation. None of that was enough. The jury convicted Brenda of first-degree murder and sentenced her to death. She became the only woman on Oklahoma's death row, held at the Mabel Bassett Correctional Center in McLeod. She has maintained her innocence ever since. Pavat's death sentence was affirmed through state appeals. He has, according to court filings as of early 2026, exhausted his avenues for appeal. Brenda's case took a different path. Her attorneys argued for years that the trial had been fundamentally unfair, that the parade of sexual evidence introduced by prosecutors had nothing to do with whether she participated in a murder conspiracy and had everything to do with painting her as a certain type of woman so the jury would be willing to sentence her to death. The Oklahoma Court of Criminal Appeals rejected that argument, finding the evidence about her personal life relevant to establishing her character and motivation. Federal courts dismissed her subsequent petitions. The case eventually reached the United States Supreme Court. On January 21, 2025, the Supreme Court issued a ruling in the case of Andrew versus White. The decision was 7-2 in Brenda's favour on a specific legal question. The court found that the Federal Appeals Court had been wrong to dismiss her due process claim outright. The majority opinion, written per curiam, acknowledged that prosecutors had spent significant time at trial introducing evidence about her sexual history, the outfits she wore to dinner, the underwear she packed for a trip, and how often she had sex in her car, much of which, the court noted, the state itself later conceded, was irrelevant. The court held that when evidence is so unduly prejudicial that it renders a trial fundamentally unfair, it can violate due process, and the lower court should not have brushed off her claim without proper analysis. The case was sent back to the 10th Circuit Court of Appeals for reconsideration. That reconsideration happened in June 2025. Federal judges at the 10th Circuit heard oral argument in Oklahoma City and took the matter under advisement. In December 2025, the court issued its ruling. The 10th Circuit affirmed Brenda Andrews' conviction and death sentence. The majority found that while the state had introduced irrelevant evidence about her personal life, much of the specific testimony she was challenging in the federal proceeding had not been properly preserved as an objection during the original state court appeal, which limited the court's ability to grant relief. A dissenting judge wrote that the prosecution had focused from start to finish on her sex life and had portrayed her in terms designed to inflame the jury rather than prove a murder charge. The Oklahoma Attorney General's office confirmed after the ruling that execution would be requested once all appeals were fully exhausted. As of March 2026, Brenda Andrew has been on death row for more than 20 years. She is 61 years old. The only woman on Oklahoma's death row, she continues to maintain that she did not conspire to kill Rob Andrew and that she was convicted not because the evidence was overwhelming, but because prosecutors decided the easiest way to death row a woman was to make a jury despise her first. Whether that argument ever prevails in a court will depend on what happens next in the appeals process. The Oklahoma Attorney General has stated clearly that an execution date will follow once the legal road ends. James Pavat is also on death row in Oklahoma. He is in his early 70s. The man who sold Rob Andrew his life insurance policy, slept with Rob's wife, and then shot Rob twice in his own garage, is waiting for a death date that has not been set. Both he and Brenda are alive and in Oklahoma prisons. Rob Andrew is not. He was 38 years old, healthy, and in the middle of a divorce when he walked into his garage on the evening of November 20th, 2001, and never walked back out. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case is set in Ohio, and it begins with nearly 300 letters exchanged between a woman and a man she met at work while he was serving time in prison. Letters so specific about what they planned to do that police were essentially handed a written confession before anyone had even been arrested. Case 4. Donna Roberts and Robert Fingerhut. Ohio. Sentenced to death, June 2003. Currently on death row. Donna Roberts and Robert Fingerhut had a complicated relationship long before anyone died. They had married, built businesses together, then divorced, but they kept living in the same house. That arrangement was partly practical and partly something harder to define. The two of them had spent years running businesses side by side in the Youngstown, Ohio area. They had managed an Avis car rental franchise at the Youngstown-Warren Regional Airport together. They later took over both the Youngstown and Warren Greyhound bus stations and turned them into successful operations. Fingerhut owned the home they shared on Fond du Lac Avenue in Howland Township, a suburb east of Youngstown. After the divorce, Roberts remained living there. They were no longer husband and wife in any legal sense, but they shared a roof, shared finances, and shared the daily texture of each other's lives. Fingerhut had taken out 2 life insurance policies worth a combined $550,000. Donna Roberts was the sole beneficiary on both. Roberts was in her late 50s when she met Nathaniel Jackson. Jackson was around 29 at the time. She had been working at a restaurant and the two became involved. The relationship developed quickly. Not long after they met, Jackson went back to prison on charges unrelated to what would eventually happen to Robert Fingerhut. The incarceration did not end the relationship. It changed the way the relationship existed. Roberts and Jackson began writing to each other. They spoke on the phone. What they wrote and what they said would later become the central evidence in one of the most straightforward capital murder prosecutions in Ohio history, because both of them discussed the plan to kill Robert Fingerhut with a directness that left investigators very little to argue about. The letters between Roberts and Jackson accumulated over the time he was incarcerated. Investigators would eventually recover nearly 300 of them. The phone calls, which were recorded because Jackson was calling from prison, numbered 18. The content of both was explicit about what Jackson intended to do when he got out. In one letter, Jackson wrote that he had come to a final decision and was going to take care of things the day after his release. He described Fingerhut as someone who would no longer be with them after a specific date, and included a drawing of a gravestone. He wrote, "Rest in piss," inside the drawing. In another communication, Jackson described the plan as something he would execute because it was time. Roberts, for her part, wrote back in terms that showed she understood what was being discussed. In one letter, referring to her frustrations with Fingerhut's control over the finances, she told Jackson to do whatever he wanted to him as soon as possible. The phone calls covered similar territory. Both of them knew these calls were recorded. Neither of them appeared to care. Roberts also took tangible steps to help prepare for what was coming. According to investigators, she purchased a mask and gloves for Jackson to use during the murder. She made arrangements to allow him access to the home where Fingerhut lived. These were not abstract gestures of support between two people writing letters. They were operational moves made by a woman who intended for her former husband to be killed in his own kitchen, and who was arranging the logistics around that outcome. What Roberts did not do, and what would later be examined carefully at trial, was take any step to warn Fingerhut or stop what was clearly being planned, in language explicit enough that even a casual reader would have understood it. Nathaniel Jackson was released from prison on December 9, 2001. Roberts was waiting for him at the gate. She picked him up herself. The two spent that night and most of the following 2 days together, staying at a hotel. On the evening of December 11, 2001, Jackson had Roberts' cell phone. Between approximately 9:45 and 11:45 that night, the two of them were in near constant contact by phone. Roberts drove to the Days Inn in Boardman, Ohio, and checked in for a week. She paid in advance. Then she drove back to the house on Fond du Lac Avenue in Howland Township. At some point that evening, Jackson entered the home. There were no signs of forced entry. He used access Roberts had arranged. Robert Fingerhut was in the kitchen. Jackson shot him multiple times. Fingerhut died on the kitchen floor. Roberts called 911. When police arrived, they found Fingerhut's body in the kitchen with multiple gunshot wounds. Roberts told officers she had just come home and discovered him. She was questioned that night and in the days that followed. When detectives asked about her personal life and relationships, Roberts told them she had been seeing a man named Carlos. She described a 6-month relationship with this person. She did not mention Nathaniel Jackson. When investigators specifically asked whether she knew Jackson, she told them she had forgotten about him. Then she said she had last seen him when she picked him up from prison, and that the most recent contact she had with him was a phone call on the morning of the murder. That account conflicted with the phone records, which showed the two of them in contact throughout the evening. It also conflicted with the hotel record from the Days Inn, which showed Roberts had checked in for a week starting that same night. The story Roberts told police began falling apart within days. The letters were found. The phone records were pulled. Investigators pieced together the timeline. Roberts had not stumbled upon a crime scene. She had organised one, waited it out at a hotel, then returned to report the body. The mask and gloves she had purchased were part of the evidence. The nearly 300 letters and 18 recorded phone calls removed whatever doubt might have existed about whether this had been planned. A grand jury indicted Roberts on charges of aggravated murder with death penalty specifications, aggravated robbery, and aggravated burglary. Jackson was charged separately. Both were tried in 2003. Jackson's trial came first. Prosecutors laid out the letters, the phone calls, the timeline, the physical evidence, and the fact that Jackson had entered the home with Roberts' help and shot Fingerhut dead for money and for the woman he had been writing to from a prison cell. Jackson was convicted of aggravated murder, aggravated robbery, and aggravated burglary. The jury sentenced him to death. His attorneys argued at various points that Roberts had been the driving force, that she had initiated the plan and manipulated a young man into carrying it out, and that Jackson's role as the person who pulled the trigger did not make him the architect. The jury rejected that framing. He was sentenced to death and sent to the Chillicothe Correctional Institution in Ross County. Roberts' trial followed. Her defense presented a version of events in which Jackson had acted on his own violent impulses, in which she had not genuinely believed he would go through with anything he had written, and in which the letters and phone calls represented the kind of exaggerated talk that happens between people in emotionally charged relationships, rather than a real plan. The prosecution dismantled that argument by walking the jury through exactly what Roberts had actually done. She had not just written letters back. She had bought the mask and gloves. She had given Jackson access to the house. She had left that night and checked into a hotel for a week. She had returned and called 911. She had then lied to police about knowing Jackson. Each of those actions went beyond anything that could be explained as passive participation in someone else's fantasy. The jury convicted her of 2 counts of aggravated murder with death penalty specifications, aggravated robbery, and aggravated burglary. On June 21, 2003, she was sentenced to death. Donna Roberts became the only woman on Ohio's death row. She was sent to the Ohio Reformatory for Women in Marysville. Roberts appealed her sentence 3 times to the Ohio Supreme Court. The first appeal resulted in a procedural remand for resentencing due to technical errors. She was resentenced to death in October 2007. A second appeal to the Ohio Supreme Court focused on the resentencing process. The court found that the trial court had failed to properly consider Roberts' allocution, her right to speak before sentence was imposed, and vacated the sentence again. She was resentenced a 3rd time, and the death penalty was reimposed. The Ohio Supreme Court reviewed the case a 3rd time and upheld the sentence in 2017, finding that the aggravating factors, primarily the murder being committed for financial gain during the course of a robbery and burglary, outweighed any mitigating circumstances and that the death penalty was proportionate and appropriate. Roberts continued appealing through the federal courts. In December 2021, she filed a petition for a writ of habeas corpus in the United States District Court for the Northern District of Ohio, raising 15 separate grounds for relief. A federal judge, after reviewing each argument in a 120-page opinion, rejected all of them in 2023. The judge found no constitutional basis for overturning the conviction or the sentence. Roberts then appealed that ruling to the 11th District Court of Appeals. As of early 2026, that appeal is still working its way through the process. Ohio executions have been on hold for years because pharmaceutical companies have been unwilling to supply the drugs used for lethal injection, meaning Roberts has been on death row without an execution date in sight for more than 2 decades. The situation for Nathaniel Jackson changed significantly in late 2025. A federal court vacated his death sentence on the grounds that his original sentencing had been unconstitutional, specifically finding procedural problems with how the death penalty had been imposed at the trial court level. Jackson was ordered to be resentenced, and a hearing was scheduled for early 2026 in Trumbull County before a common pleas judge. His murder conviction was not disturbed. What the resentencing would determine was whether he would return to death row or receive a lesser sentence. The Trumbull County Prosecutor's Office, after the ruling on Jackson, also faced a court order allowing Roberts to pursue her appeal in the 11th District. The prosecutor's office asked the Ohio Attorney General to appeal that decision, arguing Roberts' sentence should remain in place. Robert Fingerhut was 63 years old when he was shot dead in his kitchen on December 11, 2001. He had spent years building businesses with the woman who would eventually arrange his killing. He had life insurance policies that he presumably never imagined would be the reason for his death. He was found on the kitchen floor of his own home by the same police officers Donna Roberts had called to report that she had discovered him there. The people who inherited his estate and dealt with the aftermath of his murder were not the people he had named as his beneficiaries. After the conviction, Roberts obviously could not collect on the insurance policies that had been the point of everything. Donna Roberts is 79 years old. She has been on death row since 2003. She is the only woman in Ohio currently sentenced to die. Her co-defendant, Nathaniel Jackson, is in his early 50s and facing a new sentencing hearing. The home on Fond du Lac Avenue in Howland Township where Fingerhut died has long since passed out of either of their lives. The letters they wrote to each other, the phone calls they made from prison, the mask and gloves Roberts purchased, the hotel receipt from the day's inn, all of it is preserved in court records that have been reviewed by multiple levels of the judiciary and found, each time, to be sufficient proof that two people planned a murder together and then carried it out. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case involves a school vice principal in California who flew across the country to establish an alibi while his wife and 3 young children, including a 6-week-old baby, were being shot and stabbed inside their home. And the rental car he drove back across 2,000 miles of highway is what eventually put him on death row. Case 5. Vincent Brothers and Joni Harper, California. Sentenced to death, September 2007, currently on death row. Vincent Brothers was not the kind of person anyone in Bakersfield looked at sideways. He had a master's degree in education from California State University, Bakersfield. He had been in the Marine Reserves. He had worked his way up through the Bakersfield school system, starting as a substitute teacher in 1987, and had become the vice principal of John C. Fremont Elementary School by 1995. Students knew him as the tall administrator who would sometimes come out to the basketball court and play with them. Colleagues respected him. He was a regular at Sunday church services. He was visible, well-regarded, and rooted in the community, in a way that made what investigators eventually proved almost impossible for people who knew him to process. By July 2003, his wife, 3 children, and mother-in-law were dead inside their home. He had been 2,000 miles away when it happened. Getting from that fact to a death sentence took nearly 4 years and required some of the most unusual forensic evidence ever used in a California murder trial. Joni Harper was 39 years old. She and Vincent had a turbulent history before the murders. Vincent's first 2 marriages had both ended in divorce. He met Joni in Bakersfield and in 1990 was convicted of spousal abuse, a fact that prosecutors would later use to establish a pattern. Vincent and Joni's relationship moved forward despite that history. They married and had 2 children, Marquez and Lindsay, but the marriage fractured. In 2000, they divorced. In September 2001, the marriage was formally annulled due to Vincent's infidelity. By then, Joni had made clear she was done. Then, in early 2003, she discovered she was pregnant again. She and Vincent remarried in Las Vegas in January 2003, while she was carrying their 3rd child. Marshall was born approximately 4 months later. He was 6 weeks old on the day he died. Whatever had brought Joni back to the marriage in January 2003 did not hold. By April 2003, Vincent had moved out of the Bakersfield home where Joni was living with Marquez, 4 years old, Lindsay, 23 months old, and the newborn Marshall. Joni told friends the marriage was in trouble again. She told them she was afraid of Vincent. She was planning to file for divorce a second time and intended to pursue child support for all 3 children. That prospect, child support payments, a second divorce, a custody arrangement, gave prosecutors the motive they would eventually present to the jury. Vincent, they argued, looked at what was coming financially and personally and chose a different solution. On July 2, 2003, Vincent Brothers flew from Los Angeles to Columbus, Ohio, telling people he was going to visit his brother Melvin for the long 4th of July weekend. The trip had a plausible social purpose. Melvin lived in Columbus. Vincent had family there. The plan, as he presented it, was to spend about a week visiting before returning to California. What investigators later established was that upon landing in Ohio, Vincent rented a Dodge Neon from a rental car agency. He then drove that car approximately 2,000 miles south and west across the country to Bakersfield, California, arriving in time to enter his family's home on July 6, 2003. Joni, her mother Ernestine Harper, who was 70 years old and living with the family, Marquez, Lindsay, and baby Marshall were at home on the afternoon of July 6th. The family had been to church that morning, as was their routine. At some point that day, all 5 of them were shot or stabbed inside the home. Joni was shot and stabbed. The others were shot. Marquez was 4 years old. Lindsay was 23 months. Marshall was 6 weeks old. Ernestine was 70. The crime scene was staged to look like a robbery. Drawers had been pulled out. The house had been gone through. But investigators who arrived later noted something that stood out immediately.
Valuables were left behind.
Cash was in the home, credit cards were visible. A television was not taken. The ransacking did not match the behaviour of someone who had actually come to rob the place. Nobody found the bodies until July 8th. A friend of Joni's came to check on her because she had not shown up at church and had not been reachable. The friend found a sliding glass door open at the back of the home and went inside. She called 911. By the time investigators arrived, the bodies had been inside the house for approximately 2 days. The initial shock in the community was profound. 5 people, 3 generations of a family, killed inside their own home in what appeared to be a violent break-in. Detectives in Bakersfield called it the most gruesome crime scene they had encountered. Investigators flew to North Carolina, where Vincent had travelled after leaving Ohio, and interviewed him on the evening of July 8th. He had been told about the murders before they arrived.
He was waiting at a police station.
During the interview, a detective named Jeff Watts noticed something. Vincent was not asking how his family had died. He was not asking about the children. He was telling the story of his alibi, where he had been, what he had done, who he had seen. He appeared to begin hyperventilating at one point and seemed like he might vomit, but the questions about his family were not the questions he was asking. The interview ended without an arrest. Investigators did not yet have enough. Vincent's alibi appeared solid on the surface. His credit cards had been used in Columbus, Ohio on July 6th, the day of the murders. His cell phone was pinging in Ohio during the same period. Both pieces of data placed him in Columbus, not Bakersfield. He was released after the interview and eventually returned to Los Angeles. He did not attend the memorial service held for Joni, Ernestine, Marcus, Lindsay, and Marshall. He attended their funeral on July 16, 2003. In the weeks that followed, investigators quietly kept pulling at the threads of his alibi. The credit card receipts were the first thing to crack. Detectives obtained surveillance footage from the stores and gas stations where the cards had been used on July 6th. The footage did not show Vincent. It showed Melvin, his brother. Melvin had been using Vincent's credit cards and in at least one transaction had forged Vincent's signature. When confronted, Melvin gave inconsistent accounts of where Vincent had been during the crucial window between July 5th and July 8th. At times he said he had been with his brother. At other times he acknowledged he had not seen Vincent during that stretch. The cell phone data was also examined more closely. A phone pinging in Ohio does not require the person who owns it to be in Ohio. It requires the phone to be in Ohio. Vincent's phone could have been left with Melvin while Vincent was in California. Investigators then turned to the rental car. Vincent had rented a Dodge Neon from a Columbus agency on July 2nd. The odometer on the car when it was returned showed he had put approximately 5,400 miles on it over the course of the rental period. The distance from Columbus to Bakersfield and back is roughly 4,500 miles. A round trip from Ohio to California and back, with some local driving on either end, was consistent with the mileage. The rental agency's records confirmed the car had not been driven west of Michigan during a previous rental period, establishing a baseline. That mileage had been put on the car during Vincent's rental. The insect evidence is what made the brothers' case unique in the history of California forensic investigation. Prosecutors worked with entomologists at the University of California, Davis to analyze insect remains found in the radiator and on the air filter of the Dodge Neon. The remains included species of insects that are not found east of the Rocky Mountains. They are specific to the western United States. The distribution of those species, the geography of where each insect lives and does not live, placed the vehicle in the western part of the country during the window in question. An expert testified that the insects found on the car could not have gotten there if the car had only been driven in Ohio and its surrounding states. The car had been west of the Rockies. That evidence, combined with the mileage, the failed credit card alibi, and the inconsistencies in Melvin's account, built the case that Vincent had driven to California, killed his family, and driven back. Vincent Brothers was arrested in April 2004, 9 months after the murders. He was charged with 5 counts of first-degree murder Jury selection for his trial took weeks because of the intense media coverage the case had generated in Bakersfield and the surrounding region. The trial itself began in February 2007 and drew national attention. Prosecutor Lisa Green, who would later become the Kern County District Attorney, described the case to the jury as one in which Vincent brothers looked at the financial and personal consequences of a second divorce and child support payments for 3 children and decided that eliminating the problem was easier than dealing with it. She told jurors he had lied on the stand 41 or more times during his testimony. The insect experts testified, the rental car records were presented, the credit card footage showing Melvin, not Vincent, was played, the mileage was walked through in detail. The defense argued that the evidence was circumstantial, that insects could theoretically have gotten onto the car's radiator in ways other than the car being driven west, and that the alibi, while imperfect, did not prove Vincent had been in California. A defense witness was prepared to testify that Vincent had been with him in Ohio during the relevant period. That witness, Vincent's brother Troy, who had flown in from New York, was absent when the time came to take the stand. The defense rested without calling him. Vincent did take the stand himself and denied the murders. The jury did not believe him. In May 2007, the jury convicted Vincent brothers on all 5 counts of first-degree murder. The penalty phase followed. Vincent's daughter from his first relationship addressed the court and told the jury she was leaving her father's last name behind. She said she no longer had a father. In September 2007, Superior Court Judge Michael Bush sentenced Vincent brothers to death and denied a defense motion for a new trial. Brothers was transported to San Quentin State Prison. He has been on death row there since. His case has continued moving through the appeals process over the years since the conviction. In June 2024, the case was back in Kern County Court for post-conviction proceedings, 21 years after the murders. The appeals have not overturned anything. The conviction has held. California's death row population has not seen an execution since 2006, following a moratorium on capital punishment in the state, and Governor Gavin Newsom has maintained an executive order halting executions. Vincent Brothers remains on death row at San Quentin, which has been converted into a rehabilitation-focused institution, though death row inmates are housed separately. Whether California ever resumes executions is a question with no clear answer at the moment. Joni Harper was 39 years old. She had divorced the same man twice, gone back to him when she was pregnant, and was preparing to end the marriage for good when she was killed. Marquez was 4. Lindsay was 23 months. Marshall, the baby who had been alive for 6 weeks, never reached 7. Ernestine Harper, Joni's mother, was 70 years old and had been living with her daughter to help with the children. All 5 of them were found 2 days later by a friend who came to check on why Joni had not shown up to church. The man who killed them had already returned to Ohio by then. He had checked in with people. He had established that he was around. He had done his best to make sure the story made sense from a distance. What he had not counted on was the insects. __, _4__. The next case moves to Idaho, where a woman named Robin Lee Rowe woke up at a friend's house in the early hours of February 10, 1992, and told her friend she had a terrible feeling something was wrong at home, and where what investigators found in her storage unit 17 days after she had taken out the last of 6 life insurance policies on her family would eventually put her on death row for the rest of her life. Case 6. Robin Lee Rowe and Randy Rowe, Idaho. Sentenced to death, December 16, 1993. Currently on death row. Robin Lee Rowe was born on September 12, 1957. By the time she arrived in Boise, Idaho in the late 1980s, she had already lived through 2 deaths that would eventually attract the attention of investigators looking back at her history. In 1977, she lost a daughter who was ruled a sudden infant death syndrome case. In 1980, her 6-year-old son Keith died in a house fire in California. That fire had been ruled accidental. Investigators at the time found no reason to look more closely. Robin had collected life insurance on Keith following that death. Nobody connected anything yet because there was nothing official to connect. She moved forward. She found work. She met Randy Rowe. They married and settled in Boise, where Randy worked as a blue-collar labourer, and the two of them attempted to build something together.
Randy was described by people who knew him as a kind and straightforward man.
Robin was described as someone who could present well in public, but who struggled privately with spending habits that regularly outpaced whatever money was coming in. By 1992, the marriage had deteriorated to the point where Robin was no longer living at the apartment. She had moved out and was staying with a friend named Joan McHugh.
Randy remained at the duplex on Seneca Way in southwest Boise with Joshua and Tabitha, Robin's two children from a previous relationship. Joshua was 10 years old, Tabitha was 8. Robin was working at the YWCA in Boise, managing a bingo operation the organization ran as a fundraiser. What her employers did not know was that she was stealing from it. Investigators would later discover she had been systematically embezzling money from the bingo proceeds to cover her personal expenses. The debt she was accumulating and the theft she was committing were both building pressure on her life in early 1992. She was separated from her husband, living in someone else's home, and stealing from her employer to manage financially. On January 24, 1992, Robin Lee Rowe walked into an insurance office and took out the 6th life insurance policy on her family. This one, like the others, named her as the beneficiary. When added to the 5 policies already in place, the total coverage on the lives of Randy Rowe, Joshua, and Tabitha came to $276,500. She had taken out that final policy 17 days before the fire. In the early hours of February 10, 1992, a fire broke out at the duplex on Seneca Way. Boise Fire Department crews were dispatched shortly after 4 in the morning. When they got the blaze under control and entered the structure, they found 3 bodies upstairs. Randy Rowe was 34 years old, Joshua was 10, Tabitha was 8. All 3 had died from carbon monoxide poisoning in their beds, while the fire burned below them. Fire investigators began examining the scene. What they found ruled out an accidental cause almost immediately. There were 2 distinct points of origin in the fire, one near the closet door by the garage entrance, and a second in the living room. Pour patterns on the floor showed that a liquid accelerant had been spread deliberately. 3 or 4 pairs of children's underwear had been placed in the living room and used to help ignite the fire. The smoke alarm had been switched off. The electrical power to the unit had been severed. Whoever had started this fire had prepared for it and had taken steps to make sure the people sleeping upstairs would not be woken by the alarm before the carbon monoxide reached them. Robin Lee Rowe was not in the apartment that night. She was at Joan McHugh's home, where she had been staying since the separation. When investigators arrived at the scene, her alibi was in place and appeared solid. But Robin's behaviour in the hours and days after the fire raised questions for those around her. Ada County Sheriff's Detective Gary Rainey, who was the lead investigator on the case and would later become the county sheriff, noted early on that the fire had not started accidentally. The focus of the investigation shifted quickly from a tragedy to a homicide inquiry. Rainey and his colleagues began looking at everyone connected to the victims. Robin was the person most connected to all 3. As the investigation progressed, several things came together at once. Detectives discovered the 6 life insurance policies. They found that the most recent one had been purchased 17 days before the fire. They also found, through a search of a storage unit Robin kept in Meridian, Idaho, evidence that she had been stealing from the YWCA bingo operation. On February 13, 1992, Robin was arrested at the Ada County Jail on grand theft charges related to the embezzlement. She was not yet charged with murder. Bail was set at $100,000. She remained in custody while the murder investigation continued around her. Detectives also began looking further back. The death of Keith, Robin's son, in the 1980 California house fire came up during the investigation. Rainey later said publicly that he believed Robin had killed Keith in that fire and had also killed her infant daughter in 1977, but that he was unable to charge her with those deaths because the original investigations had not preserved the evidence needed. Those earlier deaths were never prosecuted. They became part of the background portrait investigators assembled of a woman with a pattern, but they were not part of the murder charges she faced in Idaho. The break in the case came from Joan McHugh. Investigators asked McHugh to place a tape recorder on her telephone and record any calls she received from Robin while Robin was in jail. McHugh agreed. On March 20th, 1992, Robin called from the Ada County Jail. During the conversation, McHugh told Robin that she had woken up during the night of the fire and had gone downstairs, but had not been able to find Robin in the house. It was a planned prompt, designed to see how Robin would respond. Robin told McHugh that she had left the residence that night, but then offered an explanation. She said she had gone outside to talk to her psychiatrist. The admission that she had left the apartment was what investigators needed. Robin's alibi had been that she was inside McHugh's home the entire night. She had just told McHugh otherwise, without realizing the call was being recorded. On March 23, 1992, while still in the Ada County Jail on the theft charges, Robin Lee Rowe was arrested for 3 counts of first-degree murder and 1 count of aggravated arson. During the investigation, detectives also discovered that Robin had been involved in a new relationship in the weeks before the fire. The man was John Blackwell, the adult son of Joan McHugh, the same woman whose home Robin had been staying at. That relationship added another layer to what had been happening in Robin's life in January and February of 1992. She was separated from Randy, had taken out the final insurance policy in late January, was stealing from her employer, had begun a relationship with her host's son, and was living away from the apartment where her husband and children slept. 17 days after the last insurance policy was signed, the apartment was on fire, and all 3 of them were dead. Robin's trial began in 1993 in Ada County District Court. The prosecution's case rested on the arson evidence, the insurance policies, the recorded phone call, and the timeline of events. Expert witnesses testified about the pour patterns and the 2 distinct points of origin that established the fire had been set deliberately. The fact that the smoke alarm had been disabled and the power cut was laid before the jury as evidence of planning and intent. Prosecutors argued that Robin had returned to the apartment after the household was asleep, set the fire using accelerant, disabled the alarm, and left, leaving Randy, Joshua, and Tabitha to die without ever waking up. The insurance policies, particularly the one purchased 17 days before the fire, were central to the prosecution's argument that the motive was financial. Robin's defense raised the possibility that Randy had been abusive toward her and presented her as someone who had suffered in the marriage. Investigators testified they had found no police reports, no official documentation, no witnesses who corroborated claims of violence by Randy. State welfare agencies had no record of visits to the home. People who knew Randy described him as non-violent. The defense also challenged specific elements of the forensic evidence and argued the state had not definitively proven Robin had been at the apartment on the night of the fire. The jury deliberated and returned guilty verdicts on each count, 3 counts of first-degree murder and 1 count of aggravated arson. The sentencing hearing took place in October 1993. The defense presented mitigating evidence about Robin's background, including a traumatic childhood that included physical and emotional abuse. A psychologist testified that she had been diagnosed with alexithymia, a condition that affects a person's ability to identify and express their own emotions, and argued this had affected her decision-making. Prosecutors countered with the aggravating circumstances, the premeditation required to purchase insurance policies, disable a smoke alarm, sever power, spread accelerant at 2 points, and leave 3 people to die while they slept. They also pointed to the multiple victims and the financial motive. On December 16, 1993, Judge Alan Schwartzman sentenced Robin Lee Rowe to death. In his remarks, the judge described her as a pathological liar. He specifically cited the life insurance policies purchased in the period leading up to the fire as evidence of deliberate, calculated planning. Robin Lee Rowe became the only woman on Idaho's death row. The appeals process stretched across the following decades. Robin raised multiple grounds for relief at various levels of the state and federal court system. She challenged the effectiveness of her trial attorneys, arguing they had not had sufficient time or resources to develop evidence about neurological damage she claimed had affected her brain function and decision-making. Medical experts later examined her and testified that she had experienced tissue loss in the left frontal lobe, placing her in the bottom few % of the population by certain measures of brain function. Her attorneys argued this information, if it had been presented at trial, might have changed the sentencing outcome. Courts at multiple levels reviewed this claim and rejected it, finding that the mitigation presented at trial had been adequate and that the neurological evidence would not have altered the result given the strength of the aggravating factors. In August 2011, United States District Court Judge B. Lynn Windmill dismissed her federal habeas corpus appeal in its entirety. The judge did clear her to seek further review of limited issues, including the ineffective assistance claim related to the neurological evidence, but the core conviction and sentence were not disturbed. The Idaho Supreme Court later dismissed an additional appeal in which Robin claimed the state had withheld evidence that could have helped her case. The withheld evidence related to the fact that a law enforcement officer had been present when McHugh recorded the phone call. The court found unanimously that this information cast no meaningful doubt on the reliability of the conviction. Robin Lee Rowe has been incarcerated at the Pocatello Women's Correctional Center in Pocatello, Idaho since her conviction. She remains the only woman on Idaho's death row. As of 2026, she is 67 years old and has spent more than 3 decades on death row. Idaho carried out its most recent execution in 2012. The state does have capital punishment on the books and has used it, but executions are rare and years pass between them. Robin's case has not attracted the same national media attention as some others, partly because the legal proceedings have been exhausted at most levels, and partly because there have been no dramatic reversals or new evidence developments that have reignited public interest. Randy Rowe was 34 years old. He had been separated from his wife and was living in the apartment with his 2 stepchildren when the fire was set. Joshua was 10 years old. Tabitha was 8. All 3 of them died from carbon monoxide in their beds in the early morning hours of February 10, 1992, without being woken by a smoke alarm that had been turned off before the fire was started. The lead investigator on the case, Gary Rainey, said publicly that in his assessment, the murders of Randy, Joshua, and Tabitha were the most premeditated for-gain killings he had ever investigated. He also said he believed, though could not prove in court, that Robin had killed 2 other children before them. The insurance money was never collected. Robin was in custody before any payout could be processed, and a person convicted of killing the insured cannot collect on the policy. The $276,500 that had been the point of 6 separate insurance transactions, the last of which was signed 17 days before 3 people died, went nowhere. It exists now only as evidence of what was being planned. The next case moves to Texas, where a former suburban police officer named Robert Fratter spent years telling everyone around him he wanted his wife dead, asked multiple people to help him find someone to do it, and eventually paid a teenage hitman $1,000 to shoot Farrah Fratter twice in the head as she pulled into her garage, while he sat in church with their 3 young children to make sure no one could place him at the scene. Case 7. Robert Fratter and Farrah Fratter, Texas, on death row, 1996 to 2023. Executed January 10, 2023. Robert Fratter and Farrah Famida Bakr married in 1983. Farrah had been born in Guildford, Surrey, England, on August 5, 1961, and had built a life in the Houston area of Texas. Robert worked as a public safety officer for Missouri City, a suburb southwest of Houston. By all outward appearances, they were a family. They had 3 children together, Bradley, Daniel, and Amber. Bradley was 7 years old when his mother was murdered. Daniel was 6. Amber was 4. Robert Fratter had been planning to have Farrah killed for years before anyone actually did it, and had told so many people about that plan, in so many different settings, that prosecutors at his eventual trial had no shortage of witnesses willing to describe what he had said. The marriage had broken down badly by the early 1990s. Farrah filed for divorce in March 1992. In her divorce filings, she alleged that Robert had made bizarre and deviant sexual demands throughout the marriage. The divorce proceedings dragged on. The couple fought over custody of the 3 children. Robert, by the accounts of people around him, became increasingly focused on the cost of what was coming, the child support payments, the custody arrangement, the financial implications of losing a divorce case while also losing access to his children. He was not subtle about how he felt or what he was considering. Co-workers from the police force later testified that they had heard him say on multiple occasions that he was unhappy about the potential child support payments and had thought about killing Farrah as a way to retain custody of his children. He said this to colleagues. He said it at work. He floated the idea to at least one friend at a diner, asking whether that person could connect him with someone willing to commit murder. He told another associate he was looking specifically for hitmen. He mentioned a racial preference for who he wanted the shooter to be. He brought a gun along to a nightclub while discussing with a friend how his wife's death could be engineered to look like a carjacking. The people who heard these things mostly did not go to police, at least not immediately. They filed what they had heard away and went on with their lives, apparently assuming that the talk was just talk. In 1994, Robert Fratter approached a man named Joseph Andrew Pristash. Pristash was 38 years old, a neighbour and workout companion of Fratter's at the gym. Fratter asked Pristash to help him find someone to kill Farah. Pristash agreed to help. He then recruited a young man named Howard Paul Guidry. Guidry was 18 years old. Pristash told Guidry the job was to shoot Robert Fratter's wife. The payment offered was $1,000 in cash and a jeep. Guidry accepted. Robert Fratter knew exactly what had been arranged. He was the origin point of the entire chain. On the evening of November 9, 1994, Farah Fratter left the house after dinner with Robert and the children. She went to get her hair cut. She was 33 years old. Robert took the 3 children to church after dinner. The youngest 2 stayed in the nursery. Bradley, the oldest, attended a catechism class. Robert Fratter was at church with his children. His alibi was being built in real time while his wife was out getting her hair done. Farah drove home and pulled into the garage of their house in Atascocita, a community in the Houston suburbs in Harris County. Guidry was waiting. He had positioned himself in the backyard behind the garage. The plan had been set up so that when Farah arrived home and entered the garage, Guidry would be there. A neighbour named Laura Holscher was across the street, sitting in her living room nursing her infant son. Holscher later testified that she saw a car pull up near the Fratter home. She watched. She heard 2 loud pops. She saw Farah Fratter fall to the ground inside the garage. She watched the garage lights go off. She saw someone move behind a tree. Then she saw a second person in a vehicle pick up the first person and drive away. She called 911. She stayed on the line and described what she was seeing. It was 7:38 in the evening. Farah had been shot twice in the head. She was still alive when paramedics arrived. Life Flight transported her to Memorial Hermann Hospital. She died from the 2 gunshot wounds to her head. Robert Fratter arrived at the hospital with his 3 children less than an hour after the shooting. Investigators who were present noted that he was not asking questions that fit the situation. A detective later recalled that Fratter was not asking what had happened to his wife, or who had shot her. He was focused on establishing where he had been. He was telling his alibi story before anyone had asked him for one. Law enforcement identified him as a person of interest immediately. He had a strong alibi. He had been at church. But the behaviour at the hospital, the complete absence of the emotional responses investigators expected, registered. Fratter was questioned and released. The investigation was only beginning. The case broke open through a coincidence. In March 1995, Howard Guidry was arrested in connection with an unrelated bank robbery. During that investigation, police recovered the firearm Guidry had used. It was a .38 Smith & Wesson revolver. The serial number was run. The gun was registered to Robert Allen Fratter. That single piece of evidence connected Guidry to Fratter directly and gave investigators the thread they needed. Guidry was questioned about the Fratter murder. He eventually admitted to being the shooter. He gave investigators Pristash. Pristash was arrested and also confessed, acknowledging he had driven the getaway car on the night of November 9, 1994, and had been the one who recruited Guidry by promising the $1,000 and the jeep. The $1,000 had been found in Robert Fratter's car. The full structure of the murder for hire was now documented. Because Texas law does not distinguish between the person who plans a murder for hire and the people who carry it out, all 3 men were charged with capital murder. The state treats the mastermind, the middleman, and the triggerman as equally culpable under the capital murder statute when the death is the result of a hired killing. Fratter was the first to be tried. His trial began on April 9, 1996. Prosecutor Kelly Siegler, who would later become one of the most prominent criminal prosecutors in Texas history,
built the case around the testimony of co-workers and friends who recounted the years of conversations in which Fratter had openly discussed killing Farah. The 7-year-old Bradley took the stand during the trial. His testimony about what he had seen and experienced was something Siegler later described as one of the most difficult moments of her career. The jury convicted Robert Fratter. He was sentenced to death in 1996. That sentence did not hold. A federal judge later overturned the conviction on the grounds that confessions from Pristash and Guidry had been admitted into evidence in ways that violated Fratter's constitutional rights. The ruling ordered a new trial. In that ruling, the federal judge also wrote that the trial evidence had shown Fratter to be egotistical, misogynistic, and vile, with a calculated desire to have his wife killed. The observation was not the legal basis for the ruling, but it was included in the written record. Fratter was retried. The second trial reached the same conclusion as the first. He was convicted again and resentenced to death in 2009. He had now been convicted twice by 2 separate juries for organising the murder of the mother of his children. The appeals process following the second conviction moved through the courts over the next decade. Fratter's attorneys raised arguments about ballistics evidence, about witness testimony, about whether a juror in the second trial had been impartial, and about claims that prosecutors had withheld information relating to a witness who had been hypnotised by investigators, a process that, Fratter's lawyers argued, had altered her recollection of the number of people she had seen at the murder scene. The United States Supreme Court declined to hear his case. The Texas Board of Pardons and Paroles reviewed his case as his execution date approached and unanimously declined to recommend commutation or a reprieve. In the days before his scheduled execution, Fratter spoke with a death penalty advocacy organisation. He described the waiting as torture. He said he was tired of 27 years of suffering and that he was, in some ways, ready for it to be over. He maintained his innocence in that conversation. He claimed the system had gotten it wrong. On January 10, 2023, the day of his scheduled execution, a Travis County civil judge issued a temporary injunction attempting to halt the execution based on claims that the pentobarbital the state intended to use was expired and medically compromised. The Texas Court of Criminal Appeals vacated that injunction within hours. The execution proceeded. Robert Fratter was 65 years old when he received the lethal injection at the state penitentiary in Huntsville, Texas. He was pronounced dead at 7:49 in the evening. He made no final statement. Farah's brother Zane Becker was present in the witness room. Bradley Becker, the boy who had been 7 years old when his mother was shot in the garage, who had taken the stand as a child during his father's first trial, was also present. Robert Fratter did not acknowledge either of them. He said nothing. Andy Kahan, the Director of Victim Services and Advocacy for Crime Stoppers of Houston, was also a witness. Afterward, Kahan told reporters that Fratter had been a coward in 1994 when he arranged the killing, and that he remained a coward at the end when he refused to extend even the smallest acknowledgement to his own son, watching from behind the glass. Farah's father, Lex Becker, had not lived to see the execution. He died in 2018 at the age of 76, having spent 24 years after his daughter's murder, raising the 3 grandchildren she left behind, Bradley, Daniel, and Amber. A family court judge had awarded custody of the Fratter children to Farah's parents shortly after her death, specifically citing Robert Fratter's alleged involvement in the murder and finding him unfit as a parent. The 3 children were raised by their maternal grandparents, growing up without their mother, without their father, and eventually without the grandfather who had stepped in to care for them. Lex Becker was buried next to Farah. Joseph Pristash, the middleman, remained on death row after Fratter's execution. He died there on June 17, 2025, having never been executed through the formal process. His death came from natural or other causes while still awaiting execution, more than 30 years after Farah Fratter was shot in her own garage for $1,000. Howard Guidry, the 18-year-old who had pulled the trigger, remained on death row as of 2026. No execution date had been set for him. He had been the triggerman in a murder for hire carried out when he was barely an adult, recruited by a gym buddy of the man who wanted his wife dead. Farah Fratter was 33 years old. She had left a marriage she described as degrading and controlling, filed for divorce, fought for her children in court, and was in the middle of that fight when her husband sent 2 men to wait for her in the dark. She had just gotten her hair cut. She pulled into her own garage and was shot twice in the head before she could get out of the car. Her children were at church with the man who had arranged it. Robert Fratter was the first person executed in Texas in 2023 and the second in the United States that year. He had spent 27 years on death row across 2 separate convictions. He never acknowledged any guilt. The murder he planned cost him everything he was trying to protect. His children were taken from him before his first trial, raised by the family of the woman he had paid to have killed, and the eldest one sat in the witness room on the night of January 10th, 2023, and watched his father die without a word. The next case moves to South Carolina, where a man named Stephen Stanko had spent years in prison, written a book about the experience, and used the credibility of that book to get close to a librarian named Laura Ling, and where what he did to her and her teenage daughter in the early hours of April 7th, 2005, would end with him becoming the 6th person executed in South Carolina in less than a year. Case 8. Stephen Stanko and Laura Ling, South Carolina, on death row, 2006 to 2025. Executed June 13th, 2025. Stephen Christopher Stanko was born on January 13th, 1968, at Guantanamo Bay Naval Base. He grew up and eventually settled in South Carolina, where people who encountered him tended to describe the same qualities. He was articulate, confident, and socially smooth in a way that made him easy to like and easy to trust. He had an ability to present himself as thoughtful and credible, and he had, by the time he was released from his first prison sentence, something concrete to back that impression up. While incarcerated for assault and kidnapping charges that had put him away in 1996, Stanko had co-written a book. It was called Living in Prison, A History of the Correctional System with an Insider's View. It was a real publication. He had actually written it. It existed in libraries. That book, and the intellectual legitimacy it gave him, became the tool he used to get close to Laura Ling. And getting close to Laura Ling is what ended her life. Stanko was released from prison in 2004, having served approximately 8.5 years of a 10-year sentence. He was 36 years old. He presented himself as a man who had done his time, reflected on it, and emerged with something to show for it: a published work, a perspective on the prison system, and the ambition to write a second book. That framing gave him a reason to spend time in libraries. It gave him a reason to approach librarians. It gave him a conversation starter that positioned him not as a recently released convict, but as an author doing research. Laura Ling worked as a librarian. She was 43 years old. She had raised 3 children largely on her own after her divorce, had earned a master's degree in library science while working and parenting simultaneously, and was described by people who knew her as genuinely kind, hardworking, and generous. A friend testified later that Laura would sometimes help out at her greenhouse for little or no pay, just because she enjoyed the company and the work. She had made Halloween costumes and Christmas stockings by hand for her children. She was, by every account given at trial, someone who gave more than she took. Stanko used the library where Laura worked to conduct what he described as research for his second book. They became friendly. The friendship developed. Eventually, Stanko moved into the home Laura shared with her children in Murrells Inlet, a coastal community in Horry County, South Carolina. He was living there as her partner by the time the events of April 2005 occurred. Laura's daughter Christina was 15 years old at the time. Articles found at Stanko's home after his arrest included material about Jeffrey Dahmer, Gary Ridgway, and other serial killers. A police spokesperson noted at the time that this suggested either an unusual personal interest in violent offenders or a man who was in the process of becoming one himself. In the early hours of April 7, 2005, Christina Ling woke up to find Stephen Stanko standing over her in her bedroom. She was 15 years old. She ran. She made it to her mother's bedroom and found Laura already on the floor, incapacitated and bleeding. What followed in that house is documented in court records from 2 separate trials and in Christina's own testimony, which she gave as a teenager and then again as a young woman at sentencing proceedings. Stanko had already attacked Laura before Christina woke. He then tied Christina up. He beat her. He assaulted her.
After that, he strangled Laura Ling and took her life. Then he went back to Christina. He cut her throat. He left her there and assumed she was dead. She was not dead. She was 15 years old with a severely wounded throat, and she survived. At some point after Stanko left, she was able to call for help. Before he was gone from the house, Stanko had packed a suitcase. He took Laura's credit card. He took her jewellery. He got into her car and drove away. It was still dark. He drove north from Murrells Inlet to Conway, a town in the same general area. Around 4 in the morning, he called a man named Henry Lee Turner. Turner was 74 years old. He and Stanko had a friendly relationship. Turner was a library patron who had gotten to know Stanko through the same library connections that had brought him to Laura. Stanko called and told Turner that his father had died. He said he needed somewhere to spend the night. Turner, who had a partner living in Charlotte, was alone that evening. He told Stanko to come over. He believed a friend was in grief and needed support. Stanko arrived at Turner's home in Conway. Turner let him in. Stanko shot Henry Turner in the head while he slept, using a pillow to muffle the sound. Turner was 74 years old. He had opened his door in the middle of the night because he believed a friend was in distress. After shooting him, Stanko went through the house. He took Turner's truck. He took money. He drained Turner's bank account using his ATM card. Then he drove away, putting distance between himself and South Carolina. Back at the house in Murrells Inlet, Christina Ling had survived her injuries and called 911. When police arrived, they found Laura Ling dead and her 15-year-old daughter alive, with a slit throat. Law enforcement in Conway checked on Henry Turner after reports of suspicious activity and found him dead. The two crime scenes, less than an hour apart geographically and connected by the same man, triggered a widespread law enforcement response. South Carolina authorities issued alerts. A $10,000 reward was offered for information leading to Stanko's capture. His face was circulated nationally. The book he had written while in prison included his name and enough biographical detail that identifying him was not difficult. The manhunt that followed covered multiple states. Stanko was arrested without incident. He did not resist when authorities caught up with him. The arrest was relatively quiet for a man who had committed 3 violent acts within a few hours and had then driven across state lines. Christina Ling, who had survived the attack and the throat wound, was alive and able to give investigators an account of what had happened inside the house. She had seen Stanko. She had been a direct victim of his actions. Her testimony, given first at the age of 16 and later at subsequent proceedings, was described by those present as composed and devastating. The legal proceedings against Stanko were split between 2 South Carolina counties. Georgetown County handled the charges related to what happened to Laura and Christina at the Murrells Inlet home. Horry County handled the charges related to Turner's death. The Georgetown County trial came first. Stanko's defense attempted to use an insanity argument, relying in part on the brain damage evidence that would later be developed more fully during the appeals process. The jury rejected the defense. In August 2006, Stanko was convicted in Georgetown County on charges that included murder, kidnapping, first-degree criminal sexual conduct, armed robbery, and assault and battery with intent to kill for his crimes against Laura and Christina. The jury sentenced him to death. 3 years later, in November 2009, Horry County held a separate trial for the murder and armed robbery of Henry Turner. Stanko was again convicted and sentenced to death a second time. He was carrying 2 death sentences when he began the appeals process. The appeals proceeded over the following 15 years. Medical experts who examined Stanko during this period found evidence of significant neurological damage. Testing showed tissue loss in the left frontal lobe and in medial brain structures, placing him in the bottom 2.4% of the population on certain measures of brain function. His legal team argued that this damage, which was documented as likely resulting from multiple head injuries throughout his life, including a birth-related injury, a blow to the head he had sustained as a teenager while shielding a classmate from an assault, and repeated sports-related head trauma, had impaired his impulse control and judgment in ways that were relevant to both his culpability and his sentence. Neurologists testified that the damage was real and measurable. They also noted that in the structured environment of prison, where routine and external controls replaced the need for internal regulation, Stanko had not been a danger to staff or other inmates over his 2 decades on death row. The South Carolina courts reviewed these arguments at multiple stages and declined to grant relief. State courts upheld both convictions and both death sentences. Federal courts reviewed his petitions and found no basis for intervention. On May 5, 2025, the United States Supreme Court denied his final petition. The denial cleared the way for an execution date to be set. The South Carolina Supreme Court issued an execution warrant on May 16, 2025, scheduling Stanko to be put to death on June 13, 2025. Under the state's procedure, the warrant was issued on a Friday and set a date 4 Fridays later, following standard practice that allows time for any remaining legal challenges to be filed and resolved. Stanko had until May 30th to choose his method of execution. South Carolina gives condemned inmates the choice between lethal injection, the electric chair, and the firing squad. Stanko initially indicated he was leaning toward the firing squad, but then changed course after details of a recent firing squad execution were published. He chose lethal injection. His attorneys made a final attempt in federal court to delay the execution, arguing that recent lethal injection executions in South Carolina had involved unusually large doses of pentobarbital, suggesting procedural problems that could result in a painful death. They cited autopsy reports showing 2 inmates who had chosen lethal injection had received extra doses of the drug and argued this indicated something had gone wrong with the initial administration. Federal District Judge Richard Gergel declined to intervene, finding no sufficient legal basis for a stay. The South Carolina courts also rejected the final challenges. On the evening of June 13, 2025, Stephen Stanko was brought to the execution chamber at Broad River Correctional Institution in Columbia. He was 57 years old. Witnesses included members of Henry Turner's family, 1 member of Laura Ling's family, a member of Stanko's own family, the solicitor from the prosecuting office, and one of his attorneys. 3 journalists were also present. Stanko was strapped to the gurney with his arms out to either side and a blanket pulled up over his chest. He looked at everyone in the witness room. His attorney, Lindsay Vann, read his prepared final statement aloud. In it, Stanko said that Christina and the rest of Laura's family, along with Henry Turner's family, had been in his thoughts and prayers every day for the 20 years he had been on death row. He said that sorry was never enough, but that it should still be said. He wrote that his execution did not represent the sum of his life, but the worst day of it. At 6:34 in the evening, he was pronounced dead. Stephen Stanko was the 6th person executed in South Carolina since the state resumed executions in September 2024, after an unintended 13-year pause caused by pharmaceutical companies refusing to supply lethal injection drugs. The state had eventually passed a law shielding the identities of drug suppliers and execution team members, which allowed the supply to resume. Before Stanko, the state had executed Freddie Owens, Richard Bernard Moore, Marion Bowman Jr., Brad Keith Sigman, and Mikal Dean Mardy in quick succession. Stanko was the 4th person executed across 4 different states during a 4-day window between June 10th and June 13th, 2025. Laura Ling was 43 years old. She had built her life carefully, working and studying and raising children at the same time, earning a graduate degree, taking care of her community greenhouse, hand-making things for the people she loved. She had met a man through the library where she worked, believed him to be who he presented himself as, and allowed him into her home. Christina Ling was 15 years old when her mother was murdered in the next room, and when she survived the same night with a slit throat. She testified against Stanko and continued to be part of the legal proceedings for the nearly 20 years it took to reach his execution date. Henry Turner was 74 years old and opened his door in the dark because he thought a friend needed him. The case drew additional attention because of the book, Living in Prison, had been written during Stanko's first incarceration for assault and kidnapping. It had been sold in good faith to publishers and to libraries. The same publication that had given him credibility, that had positioned him as a thoughtful observer of the prison system rather than a violent offender, was the mechanism he had used to move through the world after his release and to get close to a librarian who trusted him. South Carolina Governor Henry McMaster declined clemency, consistent with the practice of every South Carolina governor in the preceding 48 executions. No governor in the state had spared a death row inmate's life during that period.
Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves to Oklahoma, where a man named James Pavat sold an insurance policy to a client, began sleeping with that client's wife, and was eventually convicted and sentenced to death for shooting the same man he had sold the policy to, and where the woman who was having the affair with him became the only woman on Oklahoma's death row, a position she still occupies more than 20 years later, while her appeals continue working through the federal court system. Case 9. James Pavat and Rob Andrew, Oklahoma. Sentenced to death, 2003. Currently on death row. James Pavat was not a stranger to Rob Andrew when he sold him an $800,000 life insurance policy in February 2000. The transaction had the appearance of a routine professional interaction, a licensed insurance agent meeting with a client, going through the paperwork, processing the sale. Pavat was in his mid-40s at the time. He was known in his community as a church-going man, someone who presented himself as principled and family-oriented. He had been working in insurance long enough to have built a client base and a professional reputation. Rob Andrew was 40 years old, an advertising executive in Oklahoma City, and by February 2000, he was not yet aware that his marriage to Brenda was deteriorating past the point of recovery. He bought the policy. He listed Brenda as the beneficiary. He trusted the agent who sold it to him. That trust, extended to a man who would within the year begin sleeping with his wife, is where this story starts. The affair between Pavat and Brenda Andrew developed not long after the policy was sold. The exact timeline of when it began is not documented with precision in court records, but by the time Rob Andrew had moved out of the family home and the divorce proceedings were underway in 2001, Pavat and Brenda were involved. Pavat had told his own girlfriend, Christy Larson, that Brenda had approached him and asked him to kill Rob. He said this to Larson directly. He told her about it as the plan was forming. Larson did not contact police. She kept what she knew to herself and continued her relationship with Pavat, even as she quietly took steps to protect herself. She wrote down the serial number of a gun she had seen in Pavat's possession. She noted it and kept it somewhere safe. That piece of paper would later become one of the critical pieces of evidence connecting Pavat to the murder. The divorce between Rob and Brenda had become contentious, specifically around the $800,000 life insurance policy. Rob's attorneys were fighting to have him removed as the insured party on the policy, or to have Brenda removed as the beneficiary. Rob was 38 years old and healthy. The policy was a significant asset. Brenda and Pavat, according to prosecutors, attempted to prevent the transfer of ownership by forging Rob's signature on documents related to the policy. The forgery was identified and became part of the ongoing legal dispute. The policy could not simply be dissolved or transferred without Rob's genuine cooperation, and Rob was not cooperating. The only outcome that would leave the full $800,000 available to Brenda was Rob's death. Approximately 1 week before the murder, Pavat purchased a .22 caliber handgun. Rob Andrew owned a 16-gauge shotgun that had been at the family home when he and Brenda separated. When he moved out, Brenda refused to let him take the shotgun with him. It stayed at the house. Rob told friends about that refusal. 8 days before the murder, a witness saw Brenda at a rural area outside Oklahoma City that was commonly used for target shooting. After she left, the witness found 16-gauge shotgun shells at the site. Brenda had a key to the home of neighbours who were out of town on November 20th, 2001. When those neighbours returned after the murder, they found a 16-gauge shotgun shell and several .22 caliber bullets hidden inside their house. There had been no break-in. Only Brenda had access. On November 20th, 2001, Pavat borrowed Christy Larson's car. He told her he was going to have it serviced. He returned the car the following day. It had not been serviced. Larson discovered a .22 caliber shell casing on the floorboard. She did not call police immediately, but she kept the casing. That evening, hours before Rob was shot, Pavat moved his washer and dryer into Brenda's home. He was making himself at home in the space he expected to share with her once the obstacle was removed. The symbolism of that timing was not lost on prosecutors when they eventually laid it before a jury. Rob Andrew came to the family home that evening. The specific circumstances that brought him there that night are part of the documented record of the evening's events.
At some point in the garage of the home, someone shot Rob twice with a 16-gauge shotgun. As he fell and lay on the floor, someone shot him twice more with a .22 caliber handgun. He died on the garage floor from those wounds. Brenda Andrew was also shot, a wound to her left arm. She told police that 2 armed men had broken into the home and carried out the attack. She said she did not know them and had no idea why they had come. Pavat was not present when police arrived. He had not been seen at the home that evening by any of the officers who responded. The forensic examination of Brenda's wound was one of the first things that raised serious questions about her account. The shot to her arm had powder burns on both her clothing and her skin that were consistent with the gun being fired from within 2 inches of the wound. A shot from a normal distance during a violent home invasion by strangers does not produce that pattern. The burns indicated the gun had been pressed or held nearly against her arm when it fired. That was not consistent with being shot by an intruder. It was consistent with staging. Pavat was not yet a named suspect in the immediate hours after the shooting, but the investigation was already pointing in a direction that would eventually reach him. Brenda did not attend Rob's funeral. Instead, she left Oklahoma City with Pavat and her 2 children and drove to Mexico. They had brought what money they could access. They attempted to establish themselves there. Pavat had confided in Larson before leaving that things were going to be different, that Brenda would have access to money once the insurance situation was resolved. In Mexico, the 2 of them waited. The money did not come. The investigation in Oklahoma was advancing. American authorities were looking for them. Pavat's name had emerged through Larson's cooperation with investigators. Larson had given police the shell casing from her car floorboard. She had given them the serial number she had written down. The number matched a weapon connected to the case. Larson also told investigators what Pavat had told her, that Brenda had asked him to kill Rob, and that he had agreed. Running out of money and options, Brenda and Pavat crossed back into the United States at the border. They were arrested. Pavat was taken into custody. When questioned, he eventually confessed to the shooting. His confession was structured in a specific way. He said he had committed the shooting with a friend and explicitly denied that Brenda had any involvement or knowledge. He was protecting her. Whether that protection was genuine loyalty or a tactical decision based on some expectation of reciprocal benefit is something that only Pavat knows. What it accomplished, legally, was to give Brenda's defense a version of events in which the actual shooter was taking responsibility and clearing her. It did not work. The evidence against Brenda was independent of Pavat's account and sufficient to convict her, regardless of what he said. Pavat was tried first. The case against him was built on his confession, Larson's testimony, the shell casing from her car, the serial number she had recorded, the timeline of the handgun purchase 1 week before the murder, the movement of his washer and dryer into Brenda's home hours before Rob was shot, the ballistic evidence connecting the weapons to the scene, and the established fact that the policy on Rob's life would have paid out $800,000 to Brenda upon Rob's death. Prosecutors laid this before a jury in 2003. The defense could not adequately explain the shell casing, the gun purchase, the timing of the appliance move, or the powder burns on Brenda's arm that suggested the shot to her had been staged. The jury convicted Pavat of capital murder. He was sentenced to death in 2003. He was in his late 40s at the time of sentencing. The legal proceedings that followed Pavat's conviction moved through the Oklahoma appellate courts. His conviction and death sentence were affirmed by the Oklahoma Court of Criminal Appeals. He then pursued federal habeas corpus relief, as virtually every death row inmate does. His petitions were reviewed and rejected at successive levels of the federal court system. By the time Brenda Andrews' case was drawing national attention in early 2025, through her appeal to the United States Supreme Court, a case built on arguments about the introduction of prejudicial sexual evidence at her trial, Pavat had already been through the full appeals process. Reports from 2025 indicated he had exhausted his legal avenues. The Oklahoma Attorney General's office, which stated after the 10th Circuit's December 2025 ruling against Brenda that an execution date would be requested once all appeals were finished, had a similar situation with Pavat, a man whose legal road had reportedly ended, awaiting a date. The dynamic between Pavat and Brenda Andrew, as it played out in court and in the public record, is worth examining on its own terms, because it illustrates something about how the case actually worked. Pavat sold Rob the policy. Pavat became involved with Brenda. Pavat told his own girlfriend that Brenda had asked him to kill Rob, framing it as something initiated by her. Pavat purchased the murder weapon. Pavat borrowed the car from his girlfriend. Pavat moved his domestic appliances into Brenda's home on the day of the murder. Pavat shot Rob Andrew dead in his garage, and then, when arrested, Pavat confessed to the killing, while simultaneously claiming the woman he had been doing all of this for had nothing to do with it. Whether that was love, guilt, or calculation, the courts found the physical evidence against Brenda independently sufficient. Both of them ended up on death row in Oklahoma. Pavat is now in his early 70s. He has been on Oklahoma's death row for more than 2 decades, held at the Oklahoma State Penitentiary in McAlester. The penitentiary in McAlester is where Oklahoma carries out its executions. The state has an active execution program. Oklahoma executed multiple people in the years following a temporary pause that had been triggered by a botched lethal injection in 2015. The state resumed executions in 2021 and has continued to carry them out with relative regularity compared to many other death penalty states. Pavat's position, having reportedly exhausted his appeals, means the question of when an execution date is set for him is a matter of prosecutorial and court scheduling rather than a matter of legal uncertainty. Rob Andrew was a healthy 38-year-old man navigating a difficult divorce when he was shot 4 times in his own garage. He had been trying to protect himself financially through the legal system, fighting to have an insurance policy on his own life restructured so that the woman divorcing him could not collect $800,000 if he died. The legal system was working on that problem through the proper channels. It was not working fast enough. The man who had sold him that policy had already been sleeping with his wife for months, had already agreed to kill him, had already purchased a handgun, and had already moved household appliances into the home Rob had moved out of. None of that was visible to Rob. He drove to the house that evening and walked into the garage. Christy Larson, Pavat's girlfriend, had known for some time before the murder that Pavat had agreed to kill someone. She had not gone to police. She had instead taken quiet, protective measures, writing down a serial number, noting what she heard, positioning herself to be useful as a witness if things went wrong. When things went wrong, she cooperated fully. Her cooperation was central to the case against both Pavat and Brenda. The shell casing she preserved from the floorboard of her borrowed car, the serial number she had written down and kept, and the account she gave of what Pavat had told her before the murder were the pieces that allowed investigators to move from a staged crime scene to an indictment. James Pavat is the only person in this collection of cases who sold the victim his own life insurance policy before killing him. He is also the only person in this collection who tried, through his confession, to take full responsibility, while simultaneously using that confession to protect the woman he had done it for. That woman has been fighting her own conviction and death sentence through the courts for more than 2 decades. They are both on death row in the same state. The man who is the beneficiary of the policy they conspired to collect on is buried in Oklahoma City. The $800,000 was never paid out. The final case in this video involves a tax accountant in Dallas named John Battaglia, who called his estranged wife on the phone, kept the line open, and shot their 2 daughters while she listened, and who then went to a tattoo parlor and got their names inked on his body before going to dinner at a nearby restaurant while his wife was calling 911. Case 10. John Battaglia and Mary Jean Pearl, the murder of their daughters. Texas. On death row, 2002 to 2018. Executed, February 1st, 2018. John Battaglia and Mary Jean Pearl met and married in Dallas, Texas. Battaglia worked as a certified public accountant, running a tax preparation business. By the late 1990s, the marriage was over, but the end of the marriage did not bring an end to the violence. It escalated it. The documented history of domestic abuse that Mary Jean described to courts and to law enforcement stretched across the years of their relationship and continued after the divorce was finalized. Police reports, restraining orders, court filings, and arrest records built a paper trail that showed a man who responded to losing control over his domestic situation by using physical force and intimidation to try to reassert it. The courts responded with protective orders. Battaglia violated those orders repeatedly. Each violation led to another legal proceeding. Each proceeding added more documentation to a file that already made clear this was not a man who accepted limits placed on his behaviour by anyone, including judges. The custody arrangement that emerged from the divorce gave Mary Jean primary custody of their two daughters. Faith Battaglia was born first, Liberty Battaglia came after. By the spring of 2001, Faith was 9 years old and Liberty was 6. They were the centre of what remained of a family that had collapsed under violence and legal conflict. Battaglia had limited and supervised contact with the girls as a result of his history. The courts had imposed restrictions on his access, specifically because of the documented pattern of behaviour toward Mary Jean. Every visit, every handoff, every communication between the former spouses happened in the shadow of that history. Mary Jean had spent years documenting what he did, filing reports, appearing in court, and trying to use every legal mechanism available to protect herself and her daughters. The system responded. Protective orders were issued. Battaglia broke them. More orders were issued. The cycle continued. On May 2nd, 2001, John Battaglia had an authorised visitation with Faith and Liberty. The girls went with their father. That visit was supposed to be time the children spent with their dad, in a situation the courts had determined was permissible given his ongoing legal status. What Battaglia chose to do with that authorised access has no legal or emotional parallel in the other cases in this video. He called Mary Jean on the phone while he had the girls. She answered. What followed on that open phone line is the detail that has stayed with everyone who has covered or prosecuted this case in the more than 2 decades since it happened. Mary Jean heard her daughters. She heard Faith and Liberty screaming at their father. She heard them say, "No, Daddy, please don't do it." Then she heard gunshots. Then she heard nothing. Both girls were shot dead. Faith was 9 years old. Liberty was 6. John Battaglia shot his own daughters during a court-authorised visitation while their mother listened on the phone. He had called her. He had kept the line open. Whether that was deliberate cruelty, designed to make her hear what he was doing, or whether it was something else, is something only Battaglia understood. The courts and the people who worked the case treated it as deliberate. The act of calling Mary Jean and maintaining the connection while he killed their children was consistent with everything the documented history showed about how he operated, using access to the people around him as a mechanism of harm. After the girls were dead, Battaglia left. He did not call emergency services. He did not go to a police station. He went to a tattoo parlour in the Dallas area and had the names of his daughters tattooed on his body. Faith and Liberty. He sat in a chair and had their names permanently marked on his skin while their bodies were in the apartment where he had shot them. After the tattoo was completed, he went to a nearby restaurant for dinner. He sat and ate. Meanwhile, Mary Jean Pearl had called 911 after the phone line went dead. Law enforcement was responding. When officers located Battaglia, he was at the restaurant. He was placed under arrest without significant incident. He was taken into custody for the murders of his 2 daughters. The investigation confirmed what had happened. The cause of death for both Faith and Liberty was gunshot wounds. The weapon was recovered. The phone records documented the call to Mary Jean and the timing of the shots. The tattoo parlour visit was verified. The restaurant visit was confirmed. The sequence of events, murder, tattoo, dinner, was not disputed in any meaningful way. The question at trial was not what had happened. It was what to do about it. Prosecutors in Dallas County charged Battaglia with capital murder for killing more than one person during the same criminal transaction, which is one of the categories of murder eligible for the death penalty in Texas. Battaglia's trial proceeded in Dallas. The prosecution presented the documented history of domestic violence against Mary Jean as evidence of the relationship context in which the murders occurred. Witnesses who knew the family described the pattern of behaviour. Mary Jean herself was a central figure in the trial, having been the person on the phone when her daughters were killed and having lived through years of the abuse Battaglia had subjected her to. The defence, facing overwhelming evidence of what had happened, focused on Battaglia's mental state and attempted to present arguments that might either negate the capital murder finding or mitigate the punishment. The jury was not persuaded. Battaglia was convicted of capital murder. The sentencing phase brought forward people who had been affected by Battaglia's conduct over the years, including those who had watched him treat Mary Jean and the legal system with contempt across multiple court proceedings and protective order violations. Victim impact statements were given. The portrait presented to the jury was of a man who had spent years demonstrating that he did not accept the authority of courts, that he would violate any order placed on him, and that he was willing to use violence against the people in his life. The jury recommended the death penalty. The trial court judge accepted the recommendation and sentenced John Battaglia to death. He was sent to Texas death row. What followed over the next 16 years was an appeals process that moved through the Texas and federal court systems, while Battaglia, by most accounts from the record, remained exactly who he had always been. He did not adopt the posture of remorse that some death row inmates take on as the years pass. He maintained positions about Mary Jean, and about the divorce, and about the circumstances of his case that prosecutors and courts found consistent with the man who had committed the murders. At various points during the appeals, statements attributed to him in proceedings reflected a continued hostility toward the mother of his daughters and an unwillingness to frame what he had done in terms of accountability. One statement that entered the record during court proceedings became particularly associated with the case. Battaglia made clear to the court, in language that was direct enough to be quoted in coverage of the proceedings, that in his view, his daughters were better off dead than being raised by their mother. He said this not in a moment of breakdown, or as an expression of grief warped beyond recognition. He said it as a statement of position. Whatever psychology underlies a person arriving at that formulation, and then voicing it in a courtroom, is something that mental health professionals who reviewed the case grappled with. The courts found it aggravating, rather than mitigating. The appeals covered the standard grounds that Texas capital cases generate: questions about jury selection, about the admission of evidence, about the conduct of counsel, about the constitutionality of specific aspects of the proceedings. Texas has a highly active appellate system for capital cases, and every avenue was explored. None of the appeals succeeded in overturning the conviction or the sentence. The evidence was not in dispute. The legal arguments did not find traction. By the middle of the second decade after the murders, the legal road for John Battaglia was reaching its end. As his execution date approached in 2018, there were proceedings related to his mental competency. Under the legal standard established by the Supreme Court in Ford v. Wainwright, a person cannot be executed if they are so mentally ill that they do not understand they are about to be executed, or why. Battaglia's attorneys raised competency issues, and a court held proceedings to evaluate his mental state. The finding was that he was competent, that he understood what was happening and why. The execution was allowed to proceed. On February 1st, 2018, John Battaglia was executed by lethal injection at the state penitentiary in Huntsville, Texas. He had been on death row for approximately 16 years. He was 62 years old at the time of his execution. Faith Battaglia was 9 years old. Liberty Battaglia was 6 years old. Their names are tattooed on the body of the man who shot them, which was burned with him or disposed of in whatever manner accompanies an executed prisoner's remains. That image, the names of those two girls permanently marked on the skin of the person who killed them, applied in the hours between the murders and dinner, is the detail that separates the Battaglia case from almost every other case in this video, and from almost every other domestic murder case in the Texas records. It is not the violence alone. Violence runs through all 10 of these cases. It is the specific sequence of actions that Battaglia chose in the aftermath of killing his children that tells you something about what he thought he was doing and what he thought it meant. Mary Jean Pearl had spent years inside the machinery of the legal system trying to protect herself and her daughters. She had filed reports, she had obtained orders, she had appeared in court, she had documented everything. The system had responded with the tools it had available: restraining orders, supervised visitation, criminal proceedings for violations. None of it had been enough to prevent what happened on May 2nd, 2001. The phone call she received that evening, the one she answered and stayed on while she heard what was happening to her daughters, is something she has had to carry for every day of the more than 2 decades since. She was the primary advocate for the death penalty in Battaglia's case. She wanted him executed. She said so publicly and in court proceedings. She waited 16 years for it to happen. The domestic violence history in the Battaglia case is documented in court records that go back years before the murders. Multiple arrests, multiple protective orders, multiple violations. A judge had restricted his access to faith and liberty, specifically because of what that history showed about the risk he posed. The authorization for the May 2, 2001 visitation existed within that restricted framework. He was allowed to see his daughters under conditions the court had determined were appropriate given his conduct. He used that authorized access to kill them. That is the detail that makes the Battaglia case a particular kind of argument about what domestic violence records mean and what courts can and cannot prevent, even when the documentation is thorough and the legal responses are real. Texas has executed more people than any other state since the reinstatement of capital punishment in 1976. By the time John Battaglia was executed on February 1, 2018, the state had decades of experience with the process. He was one of hundreds of men who had passed through the Huntsville execution chamber. What distinguished his case from most of them was not the method of his death, but the specific nature of what he had done. The phone call, the open line, the daughters screaming, the tattoo parlor, the dinner, a sequence so specific and so deliberate that it has no real parallel in the Texas death row records, going back to when the state resumed executions. Faith and Liberty Battaglia were buried. Their mother continued her life in Dallas. John Battaglia sat on death row for 16 years, filed appeals, made statements in court proceedings, and was eventually executed by the same state that had tried repeatedly, through its legal mechanisms, to manage his behavior in the years before he killed his children. He had violated every order placed on him. He had faced every legal consequence available and treated each one as something to work around, rather than something to comply with. When the courts gave him supervised access to his daughters, and he used that access to call their mother and shoot them while she listened, he was doing what the documented history of his behavior said he was capable of doing. The record had been there. It had just not been enough. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.